Welcome to Gloves Off, hosted by award-winning trial and personal injury attorney Ben Johnson, founder of Ben Johnson Law. In each episode, Ben goes toe-to-toe with guests, hashing out legal matters around the most talked-about news stories and issues. We don't pull any punches, so some language and topics may not be suitable for younger listeners.
Well, good morning, everybody. The long-anticipated episode 29 of the Gloves Off podcast. Great to see everybody. Hello, and boy, do I have an esteemed panel today. We're going to be talking about civil rights update, and as many of you know, one of the reasons folks, I don't know why, would ever listen to this podcast, but they love when we get into the whole civil rights end of things because of the prevalence of it in our news right now in our everyday lives. So we're going left to right. The one and only Jason Carr. How are you, Jason?
You see, why would somebody tune in? It's to see your ever-evolving facial hair and what progress you've made toward sage, wizened old man.
Mal just shaved it down, so it's as neat and trim as it's going to be.
Looking sharp.
Thank you, buddy. And to my left, Jason's right, is the one and only Steve Fishman, who got dressed up like he often does for us. Fish?
Yeah, that's true. I was going to wear a suit to the gym.
And you thought that
it wasn't so much that it would be uncomfortable. It would have been the look from the trainer and from all the other people in the gym. Like, what the hell are you doing wearing a suit in a gym? And once I would say it was for Ben's podcast, they would all go, "Oh, of course, Ben Johnson. The guy with 14 suits and this and that and the other." They would know.
But I love his the U of M blazing right between the two Michigan State Sparties. So it's and guess what? I went to Kalamazoo College, so I don't give a shit about any of you guys. So, and the one and only Chris Desmond, Chief Appellate Attorney at Ben Johnson Law. Chris, what's going on, brother?
Not too much. I'm just learning Jason's a fellow Spartan. I didn't know.
We traded go green, go white.
We did very subtly.
There we go. All right. Let's not get into fish. I don't want to hear about basketball in the 1960s when fish kicked your guys' ass every game. All right. So let's talk about what everybody's talking about right now. And it's like every single newscast, whether it's state, federal, or otherwise, guys, it seems like civil rights are everywhere and the discussion. And I'm talking about starting with the White House and pardons of people who have been convicted. And Fish is the one and only criminal law expert on here. Fish, just, I want to go into that whole thing too much, but what the hell is going on?
Well, the problem is simple. The problem is that the president has authority to do it, and he can pardon anybody he wants. He can commute anybody's sentence that he wants. And I think personally, if we ever get a legislature that really actually pretends that they're the legislature, I think there's going to have to be some kind of maybe a constitutional convention. I can't imagine these people would agree to it, but this is ridiculous. I mean, when you read in the newspaper the kind of people who are being pardoned, and for instance, this guy whose mother is the big donor, who donated $1 million, and the next thing you know, the guy's on his way for 120 months, and now he goes home.
Reality TV stars getting pardoned.
Explain pardon, just so everybody knows.
Well, there's two things. One is a commutation, and one is a pardon. For instance, Kwame Kilpatrick, he got a commutation. He was in the process of serving that lengthy sentence.
It's when somebody hears his sentence was commuted. That's what you're talking about.
Right, exactly. Your sentence is stopped, basically, is what happens. You're freed. You're let out of jail. There are some people who've received commutations before they even started their sentence.
And this is again, in the Constitution, the president the United States can do this.
He has the authority to do it, yes.
But that doesn't wipe out your underlying conviction.
Exactly.
You were still convicted of it. You're just not in jail anymore.
And exactly. The difference between a commutation and a pardon is exactly that.
So talk about pardon now.
So you got to remember, the thing about pardon eliminates the conviction.
I didn't know that.
And what most people don't realize, particularly in federal court, generally, particularly in fraud cases, there's huge amounts of restitution. And when you get pardoned,
means what?
Restitution means paying back the money you stole from either Medicare, Medicaid.
So like Kwame's got to pay back
Well, his is not really that high, but I've represented guys that owed $20 million. It doesn't mean they can pay it, but that's what they owe. So when you get pardoned, that eliminates the conviction, which eliminates the restitution. So it's really a reward for all of your stealing. This latest guy, the guy where the mother did it, he was stealing from everybody and never paid a penny back, and now he doesn't have to pay a penny back. Wow. And that's really a significant thing. And wait, one other thing. Yep. I don't know if you guys saw, only Kwame Kilpatrick could do this. The guy's doing a monster sentence. He gets released on a commutation, and then he bitches. He's bitching. He thought he was supposed to get a pardon. He thought he had a deal to get a pardon Because why does he want the pardon? To wipe out the restitution remaining, and then he can run around and pretend he's never been convicted. So,
Well, but what does that do for his law license?
Your law license is different. You can be.
I mean, if you get pardoned, do you get your law license back?
No, you can get your law license back after being convicted and after going to prison. I have a number of friends of mine that went to jail for something, and they got their license suspended.
Remind me never to have Fish call me one of his friends. I've just.
Well, he didn't go to jail, and he didn't even get convicted.
Thank God. Thanks to Fish.
I don't know how it happened, but he didn't get convicted. But in any event, no. If people think that by getting convicted, people
meaning me standing in for the audience, because I'm like, I thought if you lost your law license, that was it. It was curtains.
No, absolutely not. There's all kinds of different things that what we all know that the Bar Association can admonish you. They can suspend you for 90 days. They can take your license for 3 years. But
suspended or then revoked is allegedly forever. But you can always try to get it back.
But I'm telling you,
doesn't mean you will.
The lawyers there's a number of friends of mine that got convicted, went to the federal joint, but they had their 3 years up, and they've been practicing law. A couple of guys I'm thinking off the top of my head for years and years and years.
A lot of times bar licenses are more about the type of crime you committed, if it was a crime. Does it reflect on your inability to be an attorney, to be trusted with clients, to be trusted with client funds, things like that? So if the crime doesn't impact your ability to just be an attorney, then it doesn't necessarily cost you your
So the moral of the story to all lawyers who are listening, go stick up a gas station. Don't steal from the client trust account, because you guys know.
That's not even funny.
You guys know when you look in the Bar Journal, if there's 15 suspensions in there, 13 of them will be for stealing, and 10 out of the 13 will be from taking it out of the client trust account.
All right, go, Jason.
My question is, as we sit here on May 30th, the talk regarding pardons or commutations is that the president might be looking at pardoning the individuals who were accused, convicted of plotting against Whitmer to take her to be assailants, whatever. In their case, if he has done this by the time you're watching or listening to this podcast and they're out, you mentioned restitution. I mean, my brain went to these guys become almost kind of celebrities to their side of the cause or to their side of the argument. What then?
Right.
Legally?
Nothing legally. If they're pardoned, they won't have any convictions, and you don't have to look to these guys to see what happens. All the January 6th rioters, they're all running around. They're on TV.
And they're celebrities.
They're celebrities, yeah, absolutely.
State of the world that we live in.
The state of this country that we live in, that's for sure.
All right, well, then let's talk about how this kind of dovetails into the United States Supreme Court and what's going on, Chris, because not even a month ago or so, there was a huge excessive force a Supreme Court argument and ruling that is going to impact all the cases that we're going to move into and talk to about today.
Significantly, it would have been helpful to have that ruling years ago, because what the Supreme Court did, this is a case called Barnes versus Felix. There's a rule that was employed in some of the federal circuits across the country that they'd call the segmented approach.
Like in beautiful Sixth Circuit, where we live.
We had
sucked.
It. So it's called the segmented approach, and it meant when you went after an officer for excessive force, the court would say, all we can do is look at the moment that the force was used. We can't look at any of the facts before it. If the police officer did a bunch of horrific things before he used force, we ignore all that. All that matters is when he used force, was it proper? The U.S. Supreme Court kind of shockingly said, we're rejecting that nationwide. We're saying that courts can't employ that rule anymore. You look at what we call the totality of the circumstances. So you consider everything, which is what we've been arguing for years.
Was that a 9-0?
Yes, it was unanimous. It was
which is crazy.
A unanimous rejection of qualified
conservatives.
That Alito and Thomas would vote for anything that might help any regular person.
Well, but this is what it's kind of like the whole body-worn camera. Who does it help the most? So arguably, and this is where we would always argue in our cases when the Sixth Circuit was using this segmented approach, it's only fair to include all of the circumstances for both people, the cop and the person, right? Because take everything into consideration that led up to the event. And back then they'd say, oh, no. And that usually helped cops in our situations more often. We think, Chris and I do at least, because we've talked about this. Why do you think the totality of the circumstances is going to end up helping really just the truth to come out on for both sides, good or bad?
Well, I mean, there are factors that police officers use when they're deciding whether or not to use force that precede that immediate moment of force, right? And so you could have a situation where a cop knows this guy has been arrested 5 previous times for violent crimes. Well, that knowledge didn't come the moment before the shot. He had that knowledge when he approached that person. There could be someone, and not to dovetail into a Patrick Lyoya conversation very briefly,
We're going
but,
to anyway.
but in the Lyoya situation, that officer knew that Patrick, in the minutes that exchange had been going on for, had been doing nothing but trying to run. And so when he chooses to shoot, our position is you've got to consider, what was Patrick doing before that shot happened? He was doing nothing violent.
He
never
away.
struck anybody, threatened anybody.
He wasn't even trying to get away. If you watch that video as many times as I have, okay, first of all, we have to remember, it's Monday morning at 8:15. Okay, so it's daylight. This is Patrick Lyoya case. Our
Right.
civil rights case.
We should probably set the table on that.
Please,
On
Jason,
April
sorry.
4th, 2022, Grand Rapids police officer Christopher Schur performed a traffic stop on Patrick Lyoya, for alleged unregistered license plates. Okay,
Which is all bullshit.
Once stopped, Lyoya exited the vehicle, and after a brief verbal interaction regarding identification, Schur and Lyoya engaged in a foot pursuit and physical altercation. So he attempted to subdue him. Schur attempted to subdue Lyoya, unsuccessfully deploying his taser before finally pinning him to the ground, and then shooting him in the back of the head. So
with obviously his gun, while Patrick was on all fours and Schur was on top of him.
this all originates with a traffic stop, and
Yes,
then
that's-
Lyoya exiting the vehicle. And you're telling me that as somebody that wasn't there, but just as an average Joe citizen, you hear that, and it sounds like this was I don't want to use the word premeditated, but there was definitely an escalation of events, and one led to the next, to the next, to the next. So to your point about, you can't take just this little bit and say, oh, it was just this, right? You got to look at the entire context.
Right.
And at what point, if Schur snapped, if to use that term, where is that emotion, just the heat of the moment, adrenaline taking over, where you pull your deadly force and you use it to the back of the head? I don't get that myself.
Well, I mean,
but-
I think that's more of a Fishman conversation, because there are heat of the moment murders that occur, but they're still classified as murders, right? It doesn't mean just because, and I'm not saying that is what occurred, that it was an emotional response. I don't know exactly what was going through Officer Schur's head in that moment, but just because you have a badge and a uniform when you do that thing doesn't necessarily mean that it's no longer murder, right? I mean, it's still the same act that would get other
at least
people in trouble.
manslaughter. Those kinds of cases usually turn into manslaughter, even if it's regular citizens, because there's it's the heat of passion, and that's part of the definition of manslaughter, as it happens but these kinds of cases, it's beyond my comprehension. That I read the summary of the Supreme Court case, but I didn't realize what this segmented thing you were talking about.
Right.
That's beyond my comprehension, that you would do that in a criminal or a civil case.
I agreed.
You
just let
can't-
everything in and let the jury make the freaking call.
Absolutely, because, and I can tell you this:
Not
if
everything, but
if
you
that
know.
had been the rule in criminal cases, I've won 3 different murder cases, homicide cases on national television for Detroit police officers. If I hadn't been allowed, and the cops hadn't been allowed to talk about what preceded the pulling of the gun, there's no way you could win, because it's clear they shot him.
And let me make this abundantly clear to our listeners in the unlikely event you don't know Steve Fishman. So Fish, in addition to being like the #1 criminal guy in Michigan in the country, okay, his specialty has been, believe it or not, all sorts of cases, but especially murder cases. And he has a subspecialty where he represents primarily City of Detroit police officers who have either shot and killed or killed people that they were trying to take into custody. So Fish's knowledge on this is so much broader and deeper than anybody that you'll ever meet anywhere. So Fish, let's just talk real quick about Lyoya, okay? And Jason, thanks for going over the facts. What's going to be really important in the civil case, we're going to talk about the status of Lyoya, because there's huge news this week and last week on the criminal case being the decision by the prosecutor not to retry that. We're going to talk about that because Fish, that's criminal law, and Fish knows all about it. But the stop that we're going to learn about in the civil case is different than the stop in the criminal case, believe it or not.
It's the same stop, though.
You would think, because they've never given us the videotape of the car, the police car, until when it's turned on, you see Schuer is going the opposite direction than the Lyoya car. They were going opposite directions. So what that tells me is, unless he has X-ray vision and his eyes can go up and do 180
How do you
degrees,
see the license
he
plate?
didn't.
Yeah.
It's all bullshit. Okay? So what he saw is two black guys going down the road, right? And doing whatever. And at least in terms of, because I can see my client's vehicle, it's in front, and then you see, what's his name, Schuer turning right into a driveway and coming back out and then pursuing. So what I'm telling you is, this guy had zero information about that fucking license plate from the beginning. And that's why, according to my co-counsel Ben Crump, this is driving while black.
I was just about to say DWB.
Yes.
And is that, again, looking at this from just an average person's point of view, is that admissible in court, a DWB,
Yes.
either defense or offense?
Yes, and it would go to the totality of the circumstances of what, if anything, gave the officer alleged reasonable suspicion or reason to believe that there was a crime or there was something amiss. So then what you have is Schuer coming back, and then he follows Patrick, right? And then you'll see he goes up to a stop sign, rolls through it, and then he turns right. He says Patrick turned right twice. He didn't. He turned once. And then Patrick pulled over to the side of the road. Cop came up behind him, and then the whole thing began. But that's when the license plate issue would have been the first time, okay? Unless there's something on the videotape that would exonerate this, okay, or explain it. That's why they didn't give it to us. That's going to be number one. Number two, once he's now behind, Schuer's behind my client's car. My client gets out of the car, okay, and he yells, "Get back in the fucking car," right? And my client at this point is almost 0.3. I think he's 0.28 shit-faced. Okay? He was drinking all night. Let's be honest. Or if he wasn't, then he had a really nasty sleep.
As well as potential language barriers.
Right? But he could speak English. But there's no question he was intoxicated. Okay? Hence, reason to, once that interaction comes around, to arrest him. Schuer didn't know he was drunk, is what he says. He thinks that helps him. Okay? So he's right up on my guy, having an altercation and so forth, and allegedly doesn't smell the booze, and he doesn't think my client's acting strange. But what I want you to do in the video next time you guys watch is look what he's wearing when he gets out of the car. He's wearing freaking sandals. He's got white socks on, and he's got flip-flops that come off almost the second that he starts to go around the car. And it's raining, I might add. Okay? And it's daylight. So what I'm telling you is, you're going to watch Patrick when he goes out around the car, and he's in the front lawn, what I'll call front lawn driveway number 1. You're going to see Patrick stop and turn around and look at the cop. The cop's chasing him. The cop is running. Patrick ain't barely running. You're going to see. So he didn't even try to get away. What he was trying to do is he was trying to get out of the street. I think he knew he was going to get arrested. And then once the cop came up on him and started using the hands and so forth, Patrick was defending himself. And then the cop does a cardinal mistake that you heard a little bit about in the criminal case, but you're going to hear all about in the civil case, is he's in a hand-on-hand confrontation. So if I'm using my two hands, Fish, you and I are scrapping, which means you'd kick my ass and I'd be on the ground. But pretend like I was still upright for a minute. If we're doing hand-to-hand, you have two hands and I have two hands, what's the last thing in the world I want to do with one of my hands?
Drop your hand.
Drop my hand. What happens?
Bam.
Right?
That's what you get.
So Schuer drops one of his two, and they are taught not to do this. In the academy, Axon, I don't know that that's in the actual. Axon is the taser, ladies and gentlemen. It's called the Axon 2. This is one of the hottest new weapons out there on the market, and that becomes important too. So he drops one of his two hands. And guess what Patrick doesn't do?
Hit him.
Doesn't hit him. Why? Because he's not trying to kick his ass. He's just trying to kind of like not get arrested, which you can't do, understandably. But it's all he's trying. And then when Schuer then takes out his taser and they're in contact with each other, one of the number one reasons why you don't take out your taser in this exchange is because once it gets close to the other person, Fish, what are you going to do?
You're going to do something
You're
like
going to
this.
do knock
Of
it.
course.
You're going to try to. It's
Of course.
instinctive.
Instinctive.
Instinctive. You're going to block it. That's what Patrick did. So you're going to read when in the training manual, he shouldn't have brought out the taser at all. If he did, he needs to back up and have space to make the taser work.
Right, to make it work. That's the most important thing.
Okay? And he's supposed to say, taser, taser, taser. Dude, if you fucking move one more step, I am going to tase you and you are going to fall on the ground. Cut it out, right? Something along those lines. Never did that. He constantly violated his training to the point where then the Grand Rapids police come in and say, oh yeah, he did everything right according to our training. No, I mean, you guys, I am telling you, when you see this and you hear, our experts were phenomenal. The experts that the prosecution had, Chris saw more than I did. I would say one was okay, the other one was okay, less.
Yeah, I mean, these are national guys who go around the country doing exactly this. They're testifying for the thin blue line
we have
crowd.
two, and the two that I'm using, and in this case, are two of the best. I'm just telling you. And one of them does 10 times more defense work for the other side than he does for play.
Can I jump in?
Please.
At any point during this altercation, and now Patrick Lyoya was driving the vehicle?
No, yes.
Was there anybody else in the vehicle?
Yes.
Yeah.
And that Fish, what's the last thing you want to do as a police officer? There's two
Turn
people
your
in the
back
car.
on and
He had his back to the front seat passenger
That's
the whole
where I'm going with
fucking
this.
time. You can't do that if you truly think that guy has a gun and could kill you. You don't do that. I am telling you, he violated so many pieces.
So
of
you're
his
telling
training.
me that he's making all these mistakes according to his training.
Yes.
And meanwhile, the guy with a gun, he could say, Patrick Lyoya's probably got a gun, and so that's why I have to use deadly force. But what about the guy in the car?
That's not what he said, though.
No, I'm saying, from my perspective, like at what point are you're thinking as the officer, I got to use deadly force on this guy, but what about the guy in the car?
Exactly. And by the way, you know what that guy in the car did? He got out of the car and began to videotape on his cell phone. So if you think he has a gun, then why didn't he shoot that guy? He knew he didn't have a gun. This is the point. Guys, this is a fucking traffic stop. Let me say that 15 times.
Let me comment after
Please,
you're done.
no, go. It's a traffic stop.
Most of the time, what you see in these situations, and I probably agree with Crump in this instance, it probably was driving while black. Number one, you got a one patrol officer car, which is really not a great idea, particularly when you're stopping a car that's got more than one person in it.
That's a great
But
point.
what happens is, what he should have done, the minute he saw it was two people, the minute he should have called in and said, hey, I need backup. I need a backup guy, because then at least it'd be 2 on 2. So what you're talking about wouldn't matter, because the second cop would be sitting right here with that guy.
He did do that.
Oh, he did? After?
He did that while he was starting to chase Patrick from behind the car and went up on the grass. He called and asked for backup. And by the way, when he shot and killed Patrick, you can hear the sirens coming.
They're coming.
Yeah, they're down the street.
He claimed he couldn't hear them, but you can hear them on the video approaching.
Is there any liability on the part of the government or the police department for putting Schur on a one-man patrol
No.
in the first place?
No, I'm telling you right
To
now,
Fish's point.
we can barely hold them accountable for shooting and killing our clients. We can't hold them accountable for any of these decisions. And Chris could try to explain Monell, which is just another. Do we even want to go here?
Sure. Well, I'll keep it quick, but sure.
Ladies and
What's
gentlemen, when a
Monell?
cop shoots, so the Grand Rapids cop shoots and kills Patrick Lyoya, everyone agrees with it. And he had his badge on. It was in the course and scope of his employment.
Well, not everyone agrees, because it didn't.
No, they
No,
agree that
he
he
shot
did.
and
Everybody
killed him.
agrees he's working as a police officer
Yes,
at the
and
time this
shot
happened.
and killed.
Right.
However, everyone thinks, because of the way the law normally works, if you're on the clock and you do something, the employer, City of Grand Rapids, is liable for it. That is true in every single area of law except,
Governmental immunity.
thank you, governmental immunity / sovereign immunity. Not true. So they say you have to prove that the city did something or didn't do something that literally led and caused this officer to do the very thing that he did. So here we've alleged that the city of Grand Rapids improperly trained and supervised Sure, because apparently he thought this was consistent with his training, but it wasn't. And now you got City of Grand Rapids coming, oh yeah, it is consistent with his training. Therefore, they should be automatically liable, but under the law, they're not. So, sorry.
We've also alleged, in addition to that, and this is one of the cases where you're very proud of what we did prior to filing suit. We found ample evidence that the city of Grand Rapids, I think they had 90 excessive force complaints over a couple years preceding these events. All of them, other than one, were dismissed.
There's two, yeah.
Two. So the city goes through and they just brush these citizen complaints off and they say, no, there was no excessive force here. What our officer did was appropriate. And so our argument has been, when you have a department that trains officers, that you go ahead and use force and we're going to clear you. And it's not going to matter. You're not going to get in trouble. That tells officers like, sure, I can do what I did that day and I'm not going to suffer any consequences. But there are two types of lawsuits you can file against the government. One is against individual employees like Sure. One is against the entities, the cities, the employers. Those are significantly harder than suing the individual employee.
In 98 to 99% of all cases where cops have killed people, and there's a trial, or at least allegations as to the cop and the city gets out on a motion and never ends up in front of the jury. It's just the cop that did it and the person that died or got hurt. Okay, so in a few years ago, Edwards Blasingame case, the $100 million verdict down in Atlanta that you both know about, okay, that was an anomaly because we actually survived with the city of Atlanta and the cop both arguing what we call this Monell. Monell is the United States Supreme Court case.
Yeah, it's the United States Supreme Court case that recognizes this theory and lays out what it is you have to prove.
So we filed that, proved it, and then in that case, right after my verdict, less than a month later, the trial judge, despite the fact that the jury answered every question, yes, did the city lack of training of this officer leading to this? Yes. Did they improperly supervise him that led to these events? Yes. The judge threw out $60 million verdict against the city because we didn't prove Monell.
He disagreed with the jury.
So what I'm telling you is, and right now in Lyoya, the city has been thrown out of the case by Judge Maloney. He said that in our lawsuit that was drafted by our good, and Ayanna Hatchett, y'all, is a great friend of ours. She's at our firm. She is our number one civil rights person. She is my right hand, left hand, and total brain. She's phenomenal. Sadly, she had a funeral to attend today. She'd be right here with us. So Hatch drafted the complaint. Chris looked at it. I looked at it, and it was consistent with how we've always filed these lawsuits. And Judge Maloney ruled without ever having an argument, oral argument, that we didn't adequately plead in this piece of paper the relationship between the lack of supervision and training and what Sure did that day. So he threw him out of court, and ever since then, for the last year and a half to 2 years, we've been filing motions to try to get him back in. And good news is on June 17, we at least get back before Judge Maloney and we get to talk to him in person. But right now, City of Grand Rapids is out of this case.
So let's go back to that day. It's raining.
Yep.
Right? It's daytime.
Yep.
All right.
They had the car.
Take Patrick Lyoya out of the driver's seat of that vehicle.
Yep.
Replace him with Fish.
Right.
As Fish looks right now.
Fish could run a lot faster than Patrick did that day. I can tell you that. I've seen him.
But driving the car.
Okay.
And so Sure drives past
Yep.
and notes that he sees Fish's profile, sees that he's Caucasian, wearing this Michigan shirt, driving the car. Does he have any reason to turn around?
Only if he had X-ray vision and could see that Fish had the wrong license plate on the car.
Yeah. Remember that's what it boils down to. The first issue always is, did the officer have the right to stop the person? If you can't say I stopped them because it's two black guys, I mean that's crazy. Obviously, you can't do it for that reason. He had to say something, and this is the first I've heard of it. That Ben says that he really couldn't see the thing to begin with.
What happened in the civil case? They stipulated that it was a proper stop.
Who stipulated?
The prosecutor.
The criminal
did.
case.
You mean in the criminal
What did I
case?
say?
The
You
civil
said
case.
Oh shit! Sorry, criminal case. Let's do that again. In the criminal case, Fish, the prosecutor agreed it was a proper
How
stop.
can that be if the video shows what you said it's
Well, the video, I don't know how, because I can't do that, right? Based on the video that I've seen. So maybe he's seen more video. Maybe there are other evidence that's not in the police reports. I've read both the police report from Grand Rapids. I've read all the police reports from Michigan State Police, and I've seen the videos they've produced to date. All I can tell you is what they've given me. So if Chris Becker has something else, I can't wait to see it. But here's where my experts are going. Let's just say there is something else and it is a proper stop, and then they go from there. Okay. But the last thing in the world I would do under these circumstances is say that's a proper stop when they're going in two different directions.
Has there ever been a legal precedent-setting case where racial profiling was either proven or disproven in the sense that this is the touchstone, cornerstone case of racial profiling, yes or no?
The answer is in criminal law, they're going to deal with this issue head on more than we do in civil law.
Yeah, I mean, although you got to remember, I was trying cases in recorder's court. I started doing this in 1973, and the city was becoming more and more black, more and more. Once Coleman was elected, he changed the police department, thank God. It was 95% white when I was growing up to a much more black department and a lot more higher percentage of black people on the jury, higher percentage of black people on the bench, higher percentage of black people just out there in the world. So I never really had, even the white cops, once Coleman came in and once they started changing everything, the white cops might have still been that way, but they never manifested that kind of a thought process. So I don't think I ever had a case where I accused the cops of stopping a guy because he was black. I mean, it was almost impossible to do in the city of Detroit because 80% of the populace was black.
And a lot of times you might have your suspicions that a stop is, we call it pretextual, right? Where there are so many laws on the books that allow police officers to stop someone. If you're speeding a couple miles over the limit, they can stop you. You don't use your blinker. In the city of Detroit, it used to be if you had something hanging from your rear view mirror, an air freshener, that's illegal. They can pull you over.
Too dark.
Now, most of the time, maybe they won't. But if they want to, they can, and they can say, well, I did it for that reason.
And let's also admit that they can make shit up.
Yeah, absolutely.
They can say, I saw that you were going too fast. You came around that corner a little too quick, and you were swerved out of your lane because they want to see what's on the inside of the car.
There was a case, and this is I think it was called People versus Gonzalez when I started out, where you could challenge the stop on the grounds of those kinds of things. But then the United States Supreme Court, I can't remember the name of the case, came out with something that said even if the stop is bullshit, if they saw the gun, then they saw the gun. That's right. That's all there was to it. So the real issue here, though, is, and this is what you guys, I think, have in terms of your plaintiff's cases, what's a reasonable thing for cops to do? Like in this case, right? Okay, his license plate was fucked up. Really? So that means you should get in a big fight, pull out your taser, pull out your gun.
That's what I'm talking about. Back to his point.
So now it's a license plate issue. Now, once he's behind him, he had the technology in his car. It was a license plate issue once he was behind him, without any question. We'll just give him that. And then now Patrick tries to go around the car. Let him. Now, what he's going to say is, yeah, but what if he had a gun and went inside one of the houses? Okay, the answer is let the guy fucking say that, right? If that's what he wants to say, the cop, because it's ridiculous. No one's going to believe that. But that's why we have juries. But since that guy other guy was in the front seat passenger, and you don't want to turn your back to him, the last thing you want to do is go chase this guy and get into a physical altercation, turn your back to the guy that you can't see, who's sitting in the car that you just pulled over. You don't want to do any of that. So you go back to your car, personally, use it as a shield, as it's called, is what I would say, but what our experts will say, whatever they do, and not engage in a physical one-on-one. Just prevent Patrick Lyoya from getting in the car, or the other alternative is I would stay right by his door, because if that guy inside that car moves,
goes for the glove box or
whatever,
or something,
then you want to make sure you can see both.
That's why the Supreme Court 9-0 decision is so important, because you cannot remove context at all.
There's kind of a saying that we have sometimes where, like, bad facts make bad law, good facts make good law, whatever. That is a case where the facts of that case were so egregious. I think the U.S. Supreme Court, even in its current composition, couldn't avoid doing what they did. It's a guy who's driving a rental car, and unbeknownst to him, there are fines for unpaid tolls.
Traffic stops.
He's driving and a cop sees him, When the cop tries to stop him and the guy doesn't stop, the cop jumps on the hood of the car, jumps on the hood of the moving car. And then when the guy doesn't stop immediately, he pulls out the gun and shoots him because he says, well, I'm on the hood of the car and it's moving and now I'm in jeopardy of being hurt. Well, you jumped on the hood of the car. You put yourself in the position. And now you're going to say, because I'm on the hood of the car, I have to shoot? Then don't get on the hood of the car.
And this
Don't
is
go TJ Hooker style.
Right. And this is another huge issue that is going to come out. And it actually was raised in the criminal case of Lyoya, which we're going to jump into next. And that is where it's called an officer-created danger. Okay? And in civil law, we have this thing, and it's been and now apparently in the Supreme Court, where if the officer does something like that, no one forced him to jump on the hood of a car. And I think the majority of us would agree that if you are having some type of a confrontation with somebody and their car is running, one of the last places you would ever go is on their hood. Because we all know if you're going to go on their hood, God forbid, you could get hurt somehow. So where white America goes, let's just be honest, because no one else talks like this based on what I read and see, say that's the criminal's fault because once he's on the hood, they never should have done anything. Sorry, folks, that's not how it works. So the officer should not stand in front of that car that's running. And we had a case up in Flint where he stood in front. He knew my client was going to try to get away. He could hear the engine. So he stepped to the side, and as the car pulled away, he stuck the gun right through the open window and shot and killed my client. Okay, we won that in the Sixth Circuit, and that was
US
on
Supreme
the
Court.
officer-created danger, and it was on totality of circumstances and segmental. They just didn't go as far then. But so these types of things are because the officer admitted in his deposition, when the car went past me, no, I was not afraid that he was going to hit me with a car because it's past me. Right? Therefore, he can't shoot my client.
Did he? So in essence, he baited the client by stepping aside, letting him go like a bullfighter?
No, what he did is he created his own danger, the officer, by standing in front of a car that was running, and he could see my client have his hand on the gear because he's right in front of him on the windshield. Once he sees that, the officer cannot now claim, another thing he would have claimed is he could have stood right there and just start shooting at my client, right? And the argument would be, this guy's trying to run me over.
Absolutely.
But only because you were the one that went out in front, knowing full well, because the car went from off, by the way, to then the engine was started by my client, and then his hand went up on the gear shaft. All right.
And that's when the officer runs in front of the vehicle.
In front of the car.
It's not like our client puts it into gear because the cop is standing in front and he wants to run him over. The car's about to move, and the officer jumps in front of the car and then says, well, now I'm in front of a moving vehicle. Well, you weren't until you jumped in front of it.
Officer created. But again, here's the great. We don't win simply because the officer did that. We allow then the jury to make the decision of whether who's at fault and so forth. And that's what I think is a huge thing that we're going to talk about more in the Lyoya cases. When it comes to a number of these issues, like this criminal trial aspect, we're not saying we simply win because this happened. We're saying give us our right to a jury trial and let the jury make the call. And as you will see throughout the United States, guys, everyone just assumes that guys and gals that do what we do win all the time. The winning percentage in trial is quite problematic if you do what I do for a living. It's probably less than 50% of trials that win. Right? Why? Because of what we're going to talk about in a minute with Fish is the bias in favor of police officers versus folks who are trying to get away or otherwise not do what the cops say. So, Fish, real quick, Lyoya criminal case. They charged the officer with second-degree murder. They went to the criminal trial. Chris was there. Ayana was there. I was there. Courtney Tucker was there. Court, thanks for going on your days. So we covered this for our clients, more for support and so forth than anything. But it's also important we watch the evidence, and so we'll know what they're going to do in the civil case. And it was a mistrial because the jury couldn't. They have to get 12-0. So Fish explained criminal and the process of having to find a guilty or not guilty verdict.
Okay, well, it's fairly simple. When you have a criminal trial, you have to have a unanimous verdict. There's 12 jurors in any felony case, and if all 12 of them don't agree, you're going to wind up with a hung jury and a mistrial. and it can go either way. I haven't had that many hung juries, but I've had them 10-2 for not guilty and 11-1 for guilty. Doesn't happen very often. Judges in general keep sending them back in, which it appeared is what that judge did.
She did.
And keep in mind about the Lyoya case, I only know what I read in the newspaper. I don't know anything more about it than that. But I can tell you this. From what I read, it sounded like both sides had experts. They
did.
And the problem with that from a criminal perspective, if people are coming there with a bias in favor of cops, okay, and now they sit there, even if they kind of think, God, he shot him in the back of the head, that's fucked up. But on the other hand, this person, these experts came in and said that his conduct was consistent with what you're supposed to do as a policeman. That doesn't necessarily save the day in a civil case because the burden of proof is 51-49. The burden of proof is proof beyond a reasonable doubt. People who are inclined in favor of the police to begin with, I can see how they would have been able to say, look, I'm not quarreling with you. I know he shot him in the back of the head.
And he
I know
shouldn't,
that.
but
and it's terrible.
Don't send him to prison.
And if it was a civil case, I can't say that those people wouldn't vote for you guys.
Right.
But we heard from this expert and that expert and this expert, and it's not, and people from the department, and they're all saying this was consistent with his training. And yes, it's true. The government had people who said it's not consistent with his training, but that's not proof. That's the way I would argue.
It was not proof beyond a reasonable doubt.
That's probably how Matt Morgula argued it. That's what I would have done.
He's a good lawyer,
He's a good lawyer.
Can I jump in real quick?
Please do.
Because something just occurred to me.
Okay.
So if this is all training based, if he acted according to the experts, he acted accordingly with his training to shoot Patrick Lyoya in the back of the head to end this situation, this altercation. Why isn't the training shoot him in the shoulders?
They never do that.
I'm glad you asked that question because seriously, because of TV and movies, people ask me that all.
There's no warning shots.
Why didn't he just wing him in the shoulder?
That's the question. Why did he wing him?
And I'm telling you because you're watching TV or you're watching movies and it's all bullshit.
Not TV, but TV.
I have had cases where police officers have shot. Listen to this. Have shot at civilians who have shot back at them from closer than I am to that table, and it hit nobody. Neither side hits any. It's one thing to be on the shooting range. It's like basketball, right? Oh yeah, you can stand there and shoot until you got somebody guarding you and pushing you. then we see. So the reason they don't do it, their training is called tap, unless it's changed. I mean, this is your tap. You shoot twice. And you aim center mass. Center mass.
And you keep on shooting until the threat stops. Exactly. And when do you think the threat stops?
When the guy falls down, right, exactly.
And the only time you shoot your gun is if you think it's necessary to save your life or the life of somebody
else. Imminently,
not just the life, great bodily harm.
Right.
But the point is that it's important for people to understand it. And sometimes I would have to say that to juries when I represented in the cop case, hey, this is not TV. This isn't where you shoot somebody and wing them in the shoulder.
Right.
That's not the way it works. You're going to hear from the experts who are going to say, can you follow that? And the jurors generally are following.
So Fish, so there's a mistrial. And that means Prosecutor Becker then had a decision to make, and it's within his discretion. Do I want to try the case again?
Right.
And ultimately, we all know in Patrick Lyoya that Chris Becker, decided not to do that. Late last week, we had a big press conference yesterday, so the family could.
The taping of this podcast being on May 30th. You're talking late last week.
That's
third week of May.
Thank you very much, Jay. So just from your perspective, you're not a prosecutor, but obviously you've been doing this and you know all about this. What kind of goes into? How does he have that decision-making ability? How's that work?
Well, the case is brought by the prosecutor's office. He's the head prosecutor. He definitely has the authority to do it.
Right.
My guess is, and I don't know, maybe you know, what was the split? Do we know?
Yeah, well, I know, and I promised him I wouldn't reveal it.
So
and then he went on TV and revealed a different number than what he told me and the family on the day that it happened. So I guess I can probably talk about that now. We were told on the day of the mistrial. I was in the room with Chris Becker, his team, and the family. And when the mistrial was declared, he told us that the jurors told him it was 7-5 split, 7 for not guilty, 5 for guilty. And that was the best it ever got in terms of the split. That's all he said. The other day on TV, he said it was 10-2, 10 not guilty, 2 guilty.
So it's interesting that you say it the way you say it, because when I saw the hung jury, the first thing I thought is, are they going to try it again?
Right.
And my guess, when he said they weren't going to try it again, it was at least at least 8-4 for not guilty.
Okay.
And honestly, if I would have had to bet 50 cents,
Right.
I would have said it was maybe 10-2 for not guilty.
Got it.
Because the truth of the matter is, and this happened with a client of mine, I represented police officer Joseph Weekly,
I remember him.
and the first
I sure do.
the first trial was a hung jury. The second trial, he was charged with manslaughter. I got rid of the manslaughter. And now he was careless use of a firearm resulting in death. It went to the jury. It was 11-1 for not guilty. Everybody knew. And Kim Worthy, correctly, in my view, it was down to a high misdemeanor. It's a 2-year offense. And 11-1 for not guilty. And they dismissed the case. So when Becker did that, I just assumed, I definitely wouldn't have thought it was 7-5. 8-4 at the least. And I actually kind of figured 10-2.
Right.
And he you know, the truth of the matter is that, you know, I can see why the family was upset, but in terms of as the prosecutor, if you don't think you're going to win, it's not wrong to dismiss the case.
Okay, so in other words,
Let me say it for this one, because remember, they don't represent the family; they represent the state.
oh, that's important.
It's a big difference.
Explain that. Listen to this shit, Jay, because you don't think about this stuff.
What has happened over time, and I've watched it occur from 1973 to now. What's happened over time, everybody puts their 2 cents worth in, and the people who are the victims, and sometimes it's not homicide, but they always want to have everything go what they want. The prosecutor of Wayne County or the prosecutor of Kent County, they represent the entire county. They have to consider all of the things that go into a trial.
Not just the family.
They don't
Why it's
represent
called the people verse.
That's why it's called instead of what you guys do when you
Right.
have it the Lyoya family versus whatever. And personally, if it was 10-2 or 9-3, and if they talk to the jurors, and you talk to the jurors and they tell you, well, we really couldn't get past blah 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 blah, you have to make a decision. Is it worth it for the county that you represent to try it again?
Okay.
It's not a matter of shitting on the Lyoya family or anything like that. I don't know Becker, by the way, but my guess is he considered it thoroughly. He didn't think they would win it, and it would be very expensive, and all this crap again with the TV and
Gosh,
gun.
this sounds like politics.
No, I don't think it's the opposite.
He's a politician. He has to run for
Yeah,
re-election.
he's got to run for re-election, but I think
So
he could,
here's where I go. I've had to retry cases, and it sucks to retry cases. No
worst.
lawyer wants to try
The
a case
worst.
more than once. But what I've never done is tried a case once where there was a mistrial, then have to come and try it again and say to my client, "Screw you, I'm dropping the case." My position is, if you're committed to the case and you thought it was worthy of bringing, then take your lumps.
okay, I mean, that's a way to look at
Now-
it, but I think when you're an elected official, it's a little bit different than being
Well,
a
I think
plaintiff's
the
lawyer.
reality is different. I don't think the mindset's different. So am I being critical of Chris Becker? No, I think Chris Becker actually, not only did he take this case, most prosecutors would not have. I said this publicly yesterday. So did Chris Desmond. So did Yana Hatchett. And even the family acknowledged that. And he tried this case himself, which is extraordinary.
Right.
The fact that we've had him do this and Karen McDonald do Oxford, and you could talk about this more than I can, Fish, is extraordinary. Right?
Totally.
These huge cases where the prosecutor, number one, does it themselves, I give them both credit for that. Okay. But the retrial thing, I would have also have appreciated. I thought about calling him. What if he, Fish, would have called me up and said, "I'm not doing this, but I can appoint you, Johnson, and one other person if you want to be special prosecutors, and then, but I'm not paying you." And you know what I would have said, and you know who I would have called and asked. Would you have done that with me?
I don't know. I don't go to state court anymore. That's my excuse.
Okay.
I never even
Bullshit.
thought.
Do you see the lawyer ditched answer, you guys? Glad this is on video.
I mean,
See the smile,
the
before,
pause there. You could have driven a
pregnant
freight
pause.
train through that
Come on,
pause.
Fish.
I won't go to Wayne County Circuit Court 3 blocks from me. You think I'm going to be in Grand Rapids and sit up there with a bunch of guys named Van somebody?
Way too many white people. I knew that was about to come. Come on.
Too many
We would
white
have been
people for
disappointed
me.
in Fish had we not heard one white. All right, so let's just do a quick update on the civil case, Chris. Go.
So, civil case is finally getting back up and running in the Western District of Michigan.
The civil case for?
In the Patrick Lyoya case against Officer Schur, or
Former.
Christopher Schur. So, one of the things that happens with governmental immunity is they can assert it multiple times in a case, and at every stage when a court says no, they get to appeal. And so when we first filed our complaint, Schur's first move was to file a motion to
Complaint
dismiss.
is the lawsuit.
Before we gather any evidence, before we've done anything, he files a motion to dismiss, which we defeated. He then goes to the United States Court of Appeals for the Sixth Circuit. We beat him there. He then goes to the United States Supreme Court. We beat him there. It's now coming back to the Western District of Michigan.
3 years later.
Where we can find, 3 years later. So
in the meantime, we can't do anything on our case.
yeah, nothing. It's
Called
stayed.
a
It's
stay,
paused.
S-T-A-Y.
And so we've been sitting still, waiting. We've been fighting it out on appeal. And now we're finally back up and running.
So then when we get back into trial court, right, they're going to go through all the depositions and all this crap. And then when we get done taking all those depositions, then they're going to file that same motion, but now say, well, now that we've seen all of their facts, Judge, this case should be thrown out of court. Judge then gets to make a ruling, yes or no, it should go to trial or not. If they lose, then they appeal again to the Sixth Circuit Court of Appeals. And if they lose, if they affirm the trial judge saying it should go to trial, then they would try to maybe go back to the United States Supreme Court again.
And then they can do it
Welcome
again if
to
we come back to
governmental
trial.
immunity and sovereign immunity. And by the way, in case you were wondering, I know you all know this because I've broken record. Any other defendant in the world, other than the United States or the government, it doesn't have to be the United States, state of Michigan, whatever, you don't have the same right. So if you try to appeal a ruling from the judge saying, oh, this case goes to trial, in the middle of a case before trial, the Court of Appeals 9.99 times out of 10 would laugh at you and say, no, go to trial. Not when you represent one of the officers
And so
of the government.
what it does is it converts a lot of our cases against the government. I mean, ones that we really take all the way to the point of trial, those cases can be 8-9 years long of litigation. And sometimes that case isn't filed until a year or two after the underlying event happened. So you could have a family that it's been 10 years, 11 years since they were injured in some way. And you got to tell them, you got to wait it out. And there's nothing we can do to speed it up. There's nothing we can do to make it faster. And that family just suffers that entire time.
In state court on this point, I am starting a trial June 17 in Macomb County that we filed in 2019. And the only reason why is because it's cops, right, involved in the crash, no lights, no sirens, speeding, wrong lane, by the cop. Rollover accident, my client had surgery. Like, why would you ever try this case? But because of governmental immunity, they've appealed it three times.
Three times we beat them at the Michigan Court of Appeals.
And now we're finally going to trial. 6 years later, in a normal case, in an automobile accident case, which is really what this is, it just happens to be against a cop, it'd be a year to 2 years tops.
What do you tell the jury when you're trying a case that happened 8 years? Do you give an explanation for it?
Well, because they appealed, no, I would be thrown in jail for that. But no, I just told them it's how long it took. I don't go into all that, but it's crazy. Go, Jason.
If we are,
We're wrapping up, so here it is,
okay,
Jason.
so
Go
all
for
right.
it.
All right. Macro,
Yep.
big picture. If the trend in society writ large is that we are moving in a more dystopian, totalitarian police state direction,
Yep.
it would seem to me that going up against governmental immunity is basically modern tilting at windmills. It's Sisyphus pushing a boulder
Do you know how
up
many
a
times
hill.
I've been called Don Quixote in the last 4 years?
How many times?
4 billion, usually by myself. Yes, it's idiotic. Other than it's the right frickin' thing to do. Governmental immunity is so crooked and it's so bad. And the fact that not one of the 3 branches of government are willing to even take a look at it and say anything about it and how bad it's gotten and the abuses of it, it just strengthens my resolve to keep on bringing it up. Because sooner or later, people are going to wake up.
Way to go, Don.
Thanks. Fishy?
I'm done.
Yeah, same.
Nothing else to say? We're going to mic drop? Well, listen, this was supposed to be like us talking about 4 cases. We barely fucking got through 1.
Yeah, but the issue's the same.
It's so good. But no, we're going to break off. We're going to turn out. We're done with episode 27. We're
Nine.
done with it.
It's 29.
What did I say? 27? I read that as a 7. Desmond, is that a 9?
I think that's a 9.
Oh, that's my handwriting.
Kinda.
So it's 29. Thanks, everybody, for listening. We're going to come right back with another episode talking about 1 or 2 other cases. It'll be shorter, though, because Fish says he's got to go.
I got to go now, actually.
All right. Bye.